Good afternoon, everybody. I know logistically, I think things have to be shifted, but I hope we can accommodate people who are joining for this session. And if, once again, thank you so much for the IIA Madras chapter for hosting us on this. So, as Karthik introduced, I'm Sujay, part of EY Tech Consulting, partner with the firm. And I have my colleague Bhavya, director, with us in the team, and then both of us would probably be spending next 30 to 45 minutes talking on one of the most talked about topic as such, one of the most buzzwords, which is data privacy, and specifically in Indian context, because as recent as in 2023, the the act was passed, assented by the government, which means after decades and decades of effort, things have come in India where data privacy is being sensitized. So we have a law in place, and probably we'll take you through the construct of this law, the key participants or the key stakeholders of this law, what it entails for different organizations, what is the journey towards compliance to it, and then probably take some use cases of relate to how things are being implemented at different organizations, what it means for us as individuals, and then happy to take your questions. Either we can take it at the end, and if anybody has any pertinent question on a topic, please feel free to chime in, and we'll be addressing them then and there. So with this, we'll quickly start now. Not sure how many of you have been following this, because data privacy as a subject in India has been doing rounds for the last 6-7 years. So just to give you a quick recap of what has happened so far, this got introduced in 2017 when the first effort was made to introduce a law on data privacy in India. Somehow things didn't move. The efforts were continuously being made. But finally, back in August 2023 is when this act was passed. It became a law. This was assented. And post that, what has happened is act will give you the requirements in terms of now it lays out the overall set of requirements, regulatory requirements. How do you implement them? Are nothing but guidances coming as part of rules. So as recent as in January this year, the government released the draft rules, and these rules are up for public consultation. So the final set of consultations was submitted to the government early this month. And now the journey is where we expect the government to formalize the rules and release the final set of rules for the implementation, and the act goes live for having an adoption period. Now, many people ask questions, what would be the adoption period at this point in time? While it's still gray, but we believe anywhere between 2 to 3 years is what the timelines which would be given to organizations. Now, before we jump into who are the main participants, and we'll draw parallels to some of the global laws which are there right now, but then the first and the foremost question is to whom this is applicable. I think that's where it all starts. So the act itself is for digital data, which means, and that's the vision the government has, and that's where if you see even the IT Act, probably hopefully by end of this year or sometime next year is where the Digital IT Act will come into play. So the idea is this is predominantly on digital data. Anything which is either in digital data or gets digitized subsequently from on a personal information basis. So any information which can be attributable to any individual, any person, will be part of this act, will be under the ambit of this act. And anything which is used to render services or businesses. Now, for example, I as an individual want to host something today at my backyard, and I invite 100 of my guests having their personal information, whether I'll be under the ambit of act, the answer is no. But at the same time, if I use that information for rendering services, goods and services in the context of this law, at that point in time, that those set of information which is being collected and processed becomes applicable. Now, many times we have been asked questions if we are processing information outside India, whether that would be applicable. So this is where the territorial aspects come into play. So any information of Indian residents which is being collected or processed for whatever purpose is defined here and still being processed outside of India, it would be applicable. But for example, any company registered in Sweden, they're not collecting directly any personal information of India, but then somebody like us accessing their site, which is .sw, at that point in time, whether it becomes applicable, the answer is no, because they are not intending to do any business in India. Their website is www.x.sw, which means they don't want to do business in India. But still, if I as an individual go and register and give my personal information to them, they would not be part of this act. However, if a Sweden company incorporates any business in India and they collect the personal information here, then this would be applicable. So this is where right now the entire applicability of this act is, and things would become more clearer in terms of as the final rules unfold. But anybody, if have any doubts in terms of the applicability, more than happy to address it at this point in time before we move forward. Sorry, please.
In case a manufacturer outside India wants to sell goods in India, then the intention is to do business in India.
Yes.
Then what will be the case of applicability?
It would be applicable if they're collecting, processing personal information. It would be applicable for them.
Okay, right.
Perfect. So now, while we would be using these terms as we progress in the next 40 odd minutes, just to familiarize all of you what this means. So there are, in data privacy, in digital DPDP Indian context, there are primarily 5 key parties to it. The first one is nothing but the data principles. Now, if anybody is aware of GDPR, which is the European Act, which was there and which is still there, which came into force 2018, they call it as data subject. They're nothing but the individuals like us whose personal information has been given, collected, processed. So those are data principles. Now, there are certain duties which the Act has laid out, and probably we'll skip all of those in the interest of time. Maybe we'll focus more on use cases, but data principles, you can draw parallel to a data subject. Moving on next, sorry. So technically no, because the people who are selling are not, they're not complying. So it is something which is not ethical, and that's why it's a cultural shift. So first and foremost is when we are giving our data to anybody, we need to be aware to whom we are giving, why we are giving. That's point number one. Second, if the person to whom we have given, if that data is being sold by that first party to somebody else, which we are not aware, at this point in time, yes, we can go ahead and we can probably raise concerns with the board for this. Yes, exactly, absolutely. So primarily, the responsibility is with the fiduciary from whom the data got stolen, which means either they failed to have sufficient controls in place, and that's why that breach has happened. That's point number one. Second, whoever has stolen that data, they would not be subjected under this act per se, because that's more of a criminal kind of an activity which would happen separately outside of this law. But within this ambit of this law, as a fiduciary, I have failed to implement sufficient controls, and the breach has happened, and which is nothing new. Breach happens across in every part of the country or the globe. So I would be, the data fiduciary would be responsible for informing about the breach, for taking necessary actions, and eventually the board would decide whether penalties have been levied to the fiduciary. But on the person who has stolen it from the fiduciary, the breach, whatever has happened, they would be subjected under other laws, but not under this law.
Correct, sir. Okay, this is clear. But there is another case also. We see that where the responsibility is to be fixed. Say, for example, today on phone, I am talking many personal things. So there may be some agent installed by the hackers in my phone, and all those things are stolen by him. Or even say, like you say, Alexa, it is also listening everything what we are speaking. So tomorrow, if data is being stolen that way, but the person says that my data has been, because it was with the data fiduciary and they have only leaked it, or it has been stolen from there, then how to establish that?
So that's where all of these necessary controls to demonstrate what we have done, what controls we have implemented, how are we monitoring and safeguarding those data. So for example, on the Alexa front, if Alexa is listening to our data, technically they are not allowed to, which means Google has to implement those necessary controls where until unless I give my consent, Alexa cannot listen or store that data. So we have, as a fiduciary, we have to demonstrate what controls we have implemented, and we are responsible for safeguarding that data. Beyond that, still a breach can happen. The breach, nobody on this earth can come and say we are absolutely risk averse. There cannot be any possibility of a vulnerability. So that may not be the case, but at the same time, what best measures we have taken is what has to be demonstrated. Sorry. So with this, just moving on quickly. So fiduciary is nothing but, in global context, are the data controllers, set of bodies or entities who define the purpose for data, why data has to be collected or data has to be processed, etc., etc. These are the bodies who define the purpose. So the most critical role in this entire ecosystem which is being played is by data fiduciary, because they are people defining the purpose. Just moving beyond data fiduciary, the subset of fiduciary are significant data fiduciaries. Now, this is something which is a new terminology or a new set of fiduciaries which has been introduced by DPDP, unlike any other global acts. What it says is set of people who are either processing sensitive information or large volumes of information would be qualified to be called as significant data fiduciaries, because their obligations would be heightened. Now, government has laid out very clearly what are those heightened obligations, whether it is to appoint a DPO mandatorily in India, whether to undergo external audits, whether to conduct DPIAs or the data privacy impact assessments mandatorily. These are heightened obligations of a significant data fiduciary. Now, just to take an example, let's say, the act or the rule doesn't call out who would be significant data fiduciaries, but based on the examples what has been laid out, it could be someone like a healthcare industry who would be processing a lot of sensitive information, or the likes of the e-commerce industries who would be having large volumes of personal information, or from a BFSI sector who may have a lot of other sensitive information as well. So these would be the set of people who would be qualified to be significant data fiduciaries. And the next one, the data processor. Now, data processors are, in layman language, would be the third parties or the fourth parties, the suppliers or the contractors, who would be processing information, processing data on a fiduciary's behalf or on a significant data fiduciary's behalf. I, as a fiduciary, as a company I'm running, I'm collecting employee data for employment purpose, but I would be outsourcing my payroll information, my payroll process. So there would be a payroll processing company doing all the activities, so they would become data processors. Same could be the case if I've outsourced my background verification activities as a company, they become data processor. Now, the global giants who are doing services, but they've outsourced certain part of their activities, whether it's the BPOs, the KPOs of the world, they would all be termed as data processors. So that's what the processors are. Now, one starking difference, if you compare with a CPRA or a GDPR, which are the global acts across, there is no direct obligation on data processor. As part of Indian Act, the obligation sits only with a fiduciary or a significant fiduciary. Now, this is something which is open for debate. Everybody is putting in their points back to the government. We also firmly believe the obligation should be equally shared at this point in time, but in the current form and state of the Act, data processors do not have direct obligations. Which means, how would you implement and pass on those obligations? Obviously, is only through contractual instruments. So that's where data processors are. And the last critical party of this ecosystem are the Data Protection Board. Now, this is something which is being formed by the government. At this point in time, it is still in process. It has not been informed who are which is the body, who are the members of this body. But this is the board who would be acting as the court of law, who would be running investigations if any complaints have to be lodged, etc., etc. Everything would be sitting with this board, Data Protection Board. So these are the key parties or in the overall ecosystem of DPDP. Any questions on these key parties who are associated? Yes, and that contract has to be between the fiduciary and the processor. So how do you design your contract, whether right to audit clauses, obligations, indemnifications, and so on and so forth, privacy schedules, security schedules, all of those becomes very, very critical now.
When you say data process, does it mean only the companies which is working on data or any software company like HR?
Only the companies who are getting or having access to personal information through data fiduciary. So those would be called as data processors.
So if you're using any HR software for processing data, that company won't be part of this data
It would be if they're processing HR data, and obviously I'm assuming when it comes to HR data, there would be personal information of employees. So if an HRMS as a SaaS application, if it is being provided, but I would still have at the backend, I'll have access, which means I would still be a processor to it. So what I probably maybe I'll invite Bhavya to just, sorry sir, please go ahead.
So what we are seeing is data fiduciary, right? When he is sharing the data to the data processor, there is nothing that is mandating the data fiduciary because he is one of the key parties in the ecosystem, right? In terms of obligation to share the data, because there is a inherent risk that by sharing the data, it's bound to be there is a leakage, right? So still the act doesn't kind of mandate a need for in terms of the data processor to have those data controls, security controls in place to see that the
No. So the act doesn't, unlike, let's say, if I'll explain with the GDPR context, now GDPR clearly says whoever is processing the data, whether the controller or the processor, both would be equally liable. Both has the equal obligations. In this case, the obligation sits with the fiduciary to ensure reasonable safeguards are there with the processor. But tomorrow, if something goes wrong in front of the court of law, it would be the fiduciary who would be responsible, not the processor.
Sir, can I not take it in a way that because the data processor and I am the data fiduciary, so when I am giving it for the processing, definitely it will be a kind of outsourcing. So that third party outsourcing risk guidelines should be applicable here.
Absolutely.
With that way I can put the responsibility as a fiduciary on the data processor.
Yes, absolutely.
Ultimate responsibility may be with the data fiduciary.
Ultimate would be with fiduciary. I would pass on that obligation back through my contracts. So that is happening. But as I said, in front of the court of law, if I have to, if there is a breach and if there's a penalty which is be levied, it would be on the fiduciary first.
By SLA, if I am able to bind him, then he will also be equally responsible.
Absolutely. But that is a back-to-back arrangement between the fiduciary and the processor, not the processor with the board directly. That's the difference here. Perfect. So I'll just invite Bhavya to probably take you through some of the exemptions. Now, there are certain exemptions as part of this act, and to a large extent, it may not be applicable in corporate scenarios, so to say, except for one of the critical exemptions on employer-employee relationship. But still, just to navigate you through some of the key exemptions which are there on the act, please.
Thanks, Sujay. While we speak about applicability, I think exemptions, they have called out very clearly. It is more related to the government. Now, the exemptions are except two critical institutes will go through. So they say that if you're processing in the interest of prevention of a detection or a fraud, right? For example, a Chennai police wants to pull all the records because there's been a fraud or a criminal, investigation. Then they do not have to seek consent of an individual. So that has been exempted because, that's the legal basis which the government has been provided to. The second is where if there is an enforcement of any legal right or a claim, again in that case, if you have been called up, whatever cause it is, it doesn't matter to get a consent from an individual. You'll be obligated to share the data there. The third is, again, the Indian court. If at all, due to criminal cases or any major investigations, they are also exempted by the DPDP law. They do not have to seek consent there. They can call you and have you validated and investigated. Also, when there is a processing of research or archiving or statistics data, but these data should not involve personal data as such. You can have these researches and archiving of data or a statistical data in an aggregated manner. So it shouldn't probably identify an individual as such. Again, they've said that for these purposes, organizations are exempted, considering they are not using the personal data. In case there is any territory, there is a cross-border transfer which has happened or a territory which is on the legal basis by the government. Again, it has not been obligated to have any contracts or others because the government takes the authority saying that it's been exempted by DPDPA. If there is a merger and acquisitions, again, at a government level, again, that has been exempted. I think two important things or the highlights is if a healthcare, right, the hospitals are exempted here. When I say exempted, they are exempted from seeking consent. There are only two lawful bases the Act calls out. One is consent, the second is legitimate use. So the healthcare, which is hospitals, are exempted from seeking consent. But having said that, they need to have security measures to protect their data, right? They're not, we wouldn't say they're not penalized if the data has been breached with respect to security of data, but they're not obligated to seek consent because there's a lot of emergencies and other things happens, hence they have been exempted. Also, they say allied healthcare professionals. This calls out your clinics, laboratories, certain therapists where you want to go for your mental health, your X-ray institutes and others. These are all exempted by the law again. The last one is the educational institutes. Because a lot of data gets collected, a lot of children's data gets collected here. Again, they are exempted, but they've not given clarity on EdTech, which is educational, the tech which we have where certain courses the students take over the internet. They've not called out that clarity. So the industry experts have put in their case to check, do they fall under educational institutes? But in case any child who is going through a proper curriculum for the betterment, the government has said that educational institutes are exempted by the law here. Now, this is very interesting. We talk day in and day out about the law, reason being there is penalty associated to it, right? Unlike GDPR, our law calls out cause of action. When I say cause of action, if you see there are about 6 causes of action here, and each one has its own penalty, right? If there is a safeguard measure, if there is a breach of a safeguard, it goes up to 250 CR. Right? Let's say if there is a breach of a children's data again, it goes up to 200 CR. Now, the question might be, what if my organization is not even making 250 CR as a turnover? Will I be liable to it, right? That's what GDPR at least had a turnover and a threshold. But I think we have been a little brutal here that there is no threshold here, right? You are penalized as per the cause of action here. And it could be cumulative penalty too. Let's say there is a security breach. Along with that, there is a children data breach. So it could go up to 450 CR. So if you see the cumulative, it is up to 800 to 850 CR. I think this is where all our conversation comes to why DPDPA is important for organization, why we have started our journey and how to safeguard data here. This is about the rules which is read in conjunction with the law. Now, like Sujay said, the draft rules was published to us. The consultation is over. MeitY says that there are about 400 consultation papers which has gone in, right? Recommendations have been provided. Now, I'll briefly touch upon what rules they have called out. Majorly, what gray areas and what more details has been provided. There are about 22 rules. Out of 22, 15 rules are directly applicable to data fiduciaries. 7 is for the Data Protection Board, right? Coming to privacy notice, very important, similar concept like GDPR. If you go to any website, I'm sure whenever you register, it will ask you that I agree and I've read to the terms and conditions and the privacy notice, right? And then you say yes, that's when you give a consent and move forward. Now, I'm not sure how many of us read privacy notice, right? So the government says that the privacy notice has to be presented to an individual at the time of collection, right? Now, what should the privacy notice consist of, right? It should be very clear, it should be precise, it should be explicit, right? The one important thing which we have not seen in any other law is the law says that it has to be in English or 22 languages as per the 8th Constitution of India. Now, 22 languages is huge for organizations to get it implemented. And there are innovative things, AI coming into picture, we might think, okay, we'll use translators. Absolutely not, because this is a law. Interpretation is different. By a technology, interpretation of the law would be different. So, 22 languages is going to be tough. So this is also goes as part of our recommendations. When I say 22, so what actually the law says is, if somebody wants to read it in Tamil or a Kannada or a Malayalam, they should be able to do so, right? So that's the ask of it. So that English or any of the 22 languages. If I'm not able to read it in English, then I have the authority as an individual to ask it to be read in Tamil or a Kannada. So it's up to you to provide it, but if asked by an individual, you have to be able to provide it. Examples of a notice and consent, I think the first one I spoke about, basically when you register online, this is more on a KYC, but the second use case is pretty interesting, right? If you download any app, this is on a telemedicine app, right? When you download an app, I'm sure you must have, they must have asked certain information for you to agree to. They also ask you, do you allow to have access to the contact list, right? Always remember that's not required. You're only signing up for a service, right? You're only signing up for telemedicine, not to allow it to the contact list, right? So this is what an example is. Be very specific as a user also when you're signing up to these privacy notices. This is just to show an example, and I was just discussing with Sujay this morning. The flight we took this morning has, when I had to check in, it had pre-checked, notices. It didn't allow me to check, right? We were just discussing about the use case. So if you see on the left-hand side, this is something called implicit consent. That means you're forced. It doesn't give you an option or a tick option to say, okay, I agree to your privacy notice or a privacy policy. While you see on the right-hand side, it's very clear. It is not even bundled. It does say that by signing in, you go ahead and agree to terms and conditions and policy, and also maybe updated about news and newsletters and others, right? Because majorly, I'm sure your Gmails and other accounts, personal accounts, are filled with spams, right? This is majorly on your newsletters, and they should be able to give option of unsubscribing and others. So this law brings in a lot of clarity on how do we move forward on it. Security safeguards, like any other regulation, even DPDPA speaks about you need to implement technical and organizational measures. Now, the question might be that why have they not called out what are the technical measures, right? It is impossible for a law to tell you there are 10 things you need to implement. Reason being, the law is there for longer term, permanent, only addendums happens on it, right? It cannot, the technology is evolving every day. So it cannot tell you that you have to implement 10 things, but the rule gives you certain examples. Rule says that you need to have encryption, access controls, maintain few logs and others. So these are the few guidance is given by the law. Coming to the intimation of a personal data breach, right? Very important for us. GDPR did talk about you have to intimate within 72 hours of identifying the breach, right? Well, DPDPA doesn't. It doesn't give you the timeline when you have to say, but it tells you two more additional things which is even more stringent. It says that in 72 hours, you will have to publish a full proof report to the government causing what is the investigation about, what is the resolution about. You also have to intimate your data subjects or a data principal if their data has been breached, right? So this becomes even more important to have a proper mechanism and security safeguard in place. This is a very interesting, and it is, I think, need of an hour. They've brought in timeline for data retention and erasure, right? The best thing is they've called out class of data fiduciaries. They've said e-commerce. They've called out online gaming intermediaries. They've called out social media. And they've called out if you are not, more than 200, not less than 200 registered users. they say that these three class of data fiduciaries mandatorily have to delete the data if the user is inactive on their platform for the 3 years of period, right? So let's say I have registered on Instagram, I am inactive for the 3 year period. Instagram, they have to send me a notice saying that, within 48 hours of deletion, saying that your data would be deleted, and they are obligated to delete it. I think this is one of the good aspect which has come out from the rule here. Contact information and queries of data processing. On your notice, it is mandatory to publish a contact information for a data principal to reach out to your organization in case of any grievances and rights and others, right? Very interesting concept which they have brought in is children's data, right? Now, if you see any other law, especially European law, who is considered as a child is maybe an age who is below 13 to 16 years. Here, anybody who is below 18 years of age is considered as a child, right? Now, let's say you take, there's a Rapido as a service we all avail. Now, I'm sure the teenagers also avail Rapido. I'm not sure if they're registered on it, right? So what the government says is, if you are collecting children's personal data, you will need to have verifiable parental consent. Without verifiable parental consent, you are not supposed to process children's data, right? I think it gives more importance to as a child, but there are maybe beauty and healthcare and a little bit of these services like Rapidos and others might have to find time to implement this, but these are the important aspects of it. Additional obligations of significant data fiduciary, Sujay spoke about it. Data principal here, we have rights. I'm also a data principal. I have rights. That's the best part of the act, right? I have a right to access information. I have a right to correct and ask for an erasure of my information. I have a right to raise a grievance redressal. I have a right to nominate. The last two rights are very unique, which is not mentioned in any other act. You can also nominate, an individual to manage your rights. I think that's the best part about the rights. We spoke about data moving outside India.
So just going back and probably whatever Bhavya just spoke about, it's very important for us to understand what does this mean for us now. Technically speaking, why these rules have been put across, and in any act, once the act is enacted, the rules are, draft rules are open up for public consultation, is for them to get industry experts' insights in terms of whether it is implementable, what are the challenges in implementing, etc. So now what we are seeing is for the last 2 odd months, there is a lot of lobbying which is happening. Different industries would probably promote certain aspects of the rules and vice versa for multiple reasons. Now, for example, if you see the Act does not specifically say, or rather the Act clearly said there is no restrictions on cross-border data transfer. However, rule has failed to give very clearly is there a requirement of data localization. So there is a lobbying which is happening. A lot of large companies are saying that data has to be stored in India, which means there will be rise of data centers in India, which means obviously the incumbents would probably get more business. So that could be one example. And there are multiple such other ones. Verifiable parental consent. Now, I don't know how many in this room probably would be in the business where the company may process children data. But unlike Europe or even US where COPA is there, where the age is, a child is considered only till the age of 13. So the chances of processing, collecting personal information of children beyond 13 to 18 is vast. That's where children start using media, online platforms and so on and so forth. So which means there is heightened cost to business, which again has to be looked into. And specifically verifiable parental consent globally, there is no right or wrong mechanism. There are multiple challenges in implementing it. So again, this is something which is probably not there are a lot of questions which are being raised by the industry folks. Now, similarly, Bhavya spoke about 22 languages. How feasible is it for me to put lawyers knowing 22 languages or having lawyers of different languages to interpret the law in the right way and then put up a notice, and my service, my product, everything changes. So every time that happens, which means I have to go back and change my notice. So how feasible it is to put, and just not about notice. If I'm giving my notice in a local language, I might also need to have my policies in local languages. So how feasible is that? So that is another point which probably is being discussed upon. So these are some of the open points, but just for all of you again to do a recap in comparing GDPR, and the reason why we take GDPR as an example is this is more matured, established, and probably in force for last 7 odd years. So if you see significant data fiduciaries, there was just no such concept. In India it has, which means the likes of the companies, all the large giants and all, they have mandatory obligations to follow. So again, cost to business goes up significantly for them. Similarly, consent manager, now this is something which was not there. It's not there in any of the law globally, but India has introduced this. I'm sure many of you would be coming in from the BFSI sector. There was a concept of the consent aggregator. So where probably I can use an aggregator to probably give my consent and revoke my consent. The same concept is here. So today I as an individual, probably I'll be giving my data to hundreds of data fiduciaries. I would not know where my data is. So and if I want to revoke a specific consent, to recollect where I have given, how I have given is a nightmare. So consent manager are the bodies in between who would enable that. So I can enroll myself with a consent manager to say, these are the 100 places where my consents are. So tomorrow if I have to revoke any specific consent from a specific fiduciary, I can do through this intermediary. So that is something which is very novel. How it would pan out, we don't know, but again, it's a huge room. It is giving birth to a completely new set of business in between. So which is exciting, but nobody knows how this would really pan out. The board is yet to call out the boundaries in which how they would operate. How would, I mean, they've given a lot of explanations of they would be liable themselves, they have to be registered with the board and so on and so forth, but a lot more has to be coming out from the rule. Notice, again, we just discussed specific on the 22 language. Contract, again, very similar, it's there, but the only thing is the fiduciary and the processor. That is something which is very critical. So many of our clients with whom we have been working, they are asking questions on how do we draft our contracts, how do we enforce. I am only the one who is obligated as a fiduciary. So a lot of amendments are bound to happen, and we are seeing a lot of those. Technically, this has just given rise to third-party risk management as a whole program now altogether. Now, if you have to go legitimate interest, we just spoke about, and processing of general data, again, something which we've been talking, so something which has to be seen. And data breach management, this is something, again, very critical for the very fact is to report a breach, certain said cyber incident has to be reported in 6 hours. While it's not enforced, not many companies do it, but then DPDP says in 72 hours, everything has to be reported back to the board as well as to the principals who get affected. Our view is, and many of the other professionals believe it should be a risk-based approach. We don't need to just go ahead and report every damn thing to the board. Until unless there is a harm to the principal, may not be necessary. So that's something again which is doing the rounds. But I just will quickly cover what are the takeaways, I think, while we have discussed, but maybe quick coverage on this. And if anybody has any questions, just feel free to ask.
We'll take questions.
Sorry.
Rule number 8, the erasure of data which is collected.
Yeah.
For 3 years you say, no, data. For the customer becoming government.
So for the, yeah, so the customers who have not used the platform for 3 years, dormant customers, they have to be mandatorily erased with a 48 hours notice.
For banks it has longer tenure.
Yes. So they have given the
These are the
classes.
class of
It is
data
only for
fiduciaries.
e-commerce, online gaming platforms, and social media intermediaries.
Can you do a suggestion? So once you do a database, anyway we're going to open up for
Okay.
questions.
Yeah, got it.
You've got about 15 minutes.
Sure. So I think now, technically now, everybody would say, sorry, you had a question? So if you don't mind, if you can just cover these 2 slides and then probably jump onto the questions and probably maybe take more use cases for you to relate to it. But all of us here are part of enterprises, organizations. So what does it mean for us really? So one, having a very strong governance established, that's the first and the foremost thing which should be there. Now, especially the significant data fiduciaries, they are bound to have a DPO. A DPO based in India, resident of India has to be there. A global company might have a global DPO, but if they have processing done in India, which is qualifying them to be significant fiduciaries, they need to have a DPO in India also. So that's one. Privacy and notice, again, the most important thing, no more bundled consents, no more hidden consents. Everything has to be explicit. So these are the things which each and every company has to look into. And consent is one part of it, but even when you give your notice and you relay your privacy policy back to the users, as Bhavya mentioned, nobody would want to probably go through hundreds of pages. Nobody does that. But as part of the act, you need to make it as simple as possible, as transparent as possible. So now companies are trying to implement layered notices, staggered way of giving policies, and so on and so forth. So there are multiple ways in which this has to be implemented by every organization. That's one key takeaway. Security measures, and I don't know if any of you noticed in the previous slide when we spoke about penalties. The highest penalty, which is of 250 crores, is because of a breach or probably not having adequate security safeguards, which means what government is trying to promote is more on data protection, and that's why the act also says data protection. So having security safeguards becomes paramount and leads to the maximum penalty. And then retention and deletion, which means in all of this, if you see second, third, and fourth, what is most important is knowing my data, where my data is, having entire visibility of my data. So as an organization, if I don't know where my data is, where am I collecting, where is it getting processed, stored, and so on and so forth, it's absolutely impossible for me to apply any control. We can probably put so many things on theory, but in practical, unless I know where my data is, probably will not be able to implement controls, which means visibility of my data becomes absolutely critical. So these are some of the key takeaways. And then the last one, which is on third-party compliance. Every organization would be working with multiple third parties, whether it is for their internal processes, whether it is for outsourced processes. How do you ensure compliance with them? Because tomorrow, if something happens, I would be first penalized. I would be first going through the court of law, and probably whatever penalties would be levied. I can then go back and fight my battle with the processor in terms of in the court of law saying this was because of this clause you breached and so on and so forth. But at the upfront, I will have to probably bear the brunt of it. And more than monetary impact, it's the reputational impact which will be at stake. And last but not least, companies who are probably working with the children data, they need to be absolutely more mindful of how they're collecting data, how they're processing data, and so on and so forth. So these are something nuances which everybody has to now start implementing. Many of the companies are on this journey. It's something which cannot be done overnight or in a span of 1 or 2 or 3 months. It is something, if you can imagine the likes of the Googles and the Metas, they're still getting breached, and millions of penalties are being levied every single day. I mean, we just Google the penalties on these companies. Every single day in any part of the world, they're getting penalized, which means this is not as straightforward. It's difficult. It's a cultural shift, and we hope probably 5 years down the line, we see that cultural shift in Indian context. But I think that's what we had. I mean, this is straightforward. I think we can, but more than happy to now take questions and explain with use cases.
So thanks, Sujay and Bhavya. I think definitely it's a great session. So now we'll quickly open up for Q&A. I request people to raise your hand. I'll just pass on the mic.
You spoke a lot about these rules, right? And I was just kind of thinking about each rule, and I was thinking, okay, litigation 1, litigation 2, litigation 8, right? So in terms of a scale of 1 to 10, right, from a practical implementation perspective, where do you see that? I mean, I see it like 3, right, in the next 2 or 3 years, but EY perspective would be good. Maybe if you say 8, then we'll look to hire you to implement.
Unfortunately or fortunately, it is bound to be in that scale, given that that's what the direction is. So today, it's no more of a choice which is there. This is a mandate, and that's where this act is there. Earlier, if you see, prior to this act coming into force, we still had IIA Act Section 43A, which still somewhere covered personal information. But because that was not a full-fledged act on data privacy, it was not as enforceable. But today, now this entire framework has been put across. So I think even if we want or don't want, we have to be at that mark of being compliant. So the point is, I'll give you a classic example. When GDPR came into force on, I think it was 18th of May 2018. On that particular day, the amount of complaints which were registered probably took the board months and months to get over and resolve, which means people are just sitting outside to put across those claims. So I think it's bound for each and every organization to probably be compliant.
Hope that answers your question.
We will see in time how this
Evolves.
But again, also to add to it, if you see an act which comes will not be in the best of the shape in the day one. It matures. See, even GDPR when it came in 2018 and till date we are 25, 7 years down the line, there are working parties which are there, which has been formed, and there are amendments and there are nuances which gets clarified. So it's not possible for any act to be 100 on 100 on day one. It's a journey.
Just on the follow-up, essentially, we know the finality, which is more of a civil standpoint. Do you see anything going in the direction of criminal act?
It is not in this act, but if I have to take an example, let's say in KSA, Kingdom of Saudi Arabia, that's the only act at this point in time which has a criminal penalty beyond civil penalty if there's a breach. So at this point in time, this act doesn't take lead towards criminal penalty, but yes, there has been an example or a use case like a KSA law, which was just which happened last year, which has a criminal penalty as well.
But there's also one penalty for a data principal in case I'm abusing my right. I'm just penalizing an organization for a wrongdoing, right? There's 10,000 rupees as a penalty. Other than that, there's no penalty as such.
high incentive to do.
Right. Two questions. So when we talked about in terms of the exemptions, right? Certain institutions. So is it a blanket exemptions or is it on a case-to-case basis? Because each of those institutions can be in kind of doing multiple set of activities or things, right? So is it?
It's a case-to-case basis. It's not a blanket exemption. So even somebody who's in the healthcare industry, it's not a blanket exemption where they can do anything and everything and they would be exempted. That's not the thing. The reason why, for example, exemption has been put on the healthcare industry is instances of emergency. So at that point in time, I would not wait to take consent and then go ahead and do and verify and also and so forth. Hence, those exemptions are there. And same is the case in education or children schooling education sector. But then again, these companies, and Bhavya mentioned EdTech, right? They have grown beyond just imparting education. They would help you move abroad and so on and so forth. So at that point in time, case-to-case basis, you would not be exempted.
Got it. And second is, now kind of this law is passed and we are expecting that to be fully operational in the next 2 to 3 years, right? So are there any transitional kind of requirements where kind of institutions or the organizations on a phased manner the next 2 to 3 years, the time when this becomes fully effective, I am kind of ready in terms of
so they have not, there is no such concept they have defined in terms of phased manner, but what they say is once, and we again only have to go back and take examples of what has happened in the past, whether it is the US California Act of CPRA or GDPR and so on and so forth. So what they did was, once the act was enacted, the law was enacted, and then the rules were clarified and it became a formal rule, they give an adoption period. Now in this, GDPR gave 2 years, CPRA has given 2 years. So during that period, you have to comply. It doesn't mean you have to do this in 6 months and then next in 12 months, nothing of that sort. By end of those 2-year period, everybody should be complying to it.
So what if in terms of during the journey towards compliance, right, there is bound to be gaps?
There will be.
That we kind of looked upon from the act in terms of mean that in terms of kind of.
No, absolutely. It's a very, very valid question and a fair question which probably gets asked. Now what happens is on 1st of Jan 27, that everything goes live, adoption period is over. Now, but let's say something, and I tomorrow go and put a complaint on 2nd of Jan for my historical record. Probably that would not be admissible.
Thank you. Anyone would like to ask a question? Sure.
Yeah, hi, I'm Pramod from Ashok Leyland. I have a very specific question. As part of the exemptions, we were talking about prevention, detection, or investigation of offense under any law. Is there any restriction on who conducts the investigation? Because the example that was given was of the police. If suppose as a HR or as an auditor or as a third party employed by the organization, I have to carry out an investigation on an individual or any other person associated with that individual. Should I look for consent, or how can I operate?
So if I understand your question right, the exemption what we mentioned, let's say, which is more to do with any government investigation.
Correct.
Not on a corporate body investigation. So today, if as a company, there is something which has happened and we need to run a background check or we have to investigate further and all, at those cases, this is not exempted. However, if it's a government related investigation, whether it's through the channels of a police or if it is through for statistical purposes or if it is for the national sovereignty and all, in those cases exemptions would apply, not for enterprise or corporate related activities.
I understand. And maybe if at a point where an FIR is registered, it becomes a government investigation.
Yes, absolutely.
Okay, thank you.
From the point of audit, suppose in a organization when this act is already there, if I have to do the audit for a continuous basis, whether it is seeing the security of data, somewhere as a auditor I will have to assess whether for that any consent will be required.
Yes. So as an auditor, if you see at this point in time, even before this act came, everybody upfront signs a contract of confidentiality because that would be more on confidentiality related clauses rather than on privacy related, because even if I'm doing an audit, I would not be consuming or processing that personal information. My obligation would be to maintain confidentiality as an auditor for that data. So obviously I'll be bound by confidentiality clauses.
Then who will be providing that consent? Because on behalf of data fiduciary, I may be doing that audit to ensure that all those things are properly safeguarded, all those measures are there. But then as a auditor from whom I will be seeking the consent, or who will be giving me the consent, or as a data fiduciary on behalf of the data principals, they will be giving me the consent.
Data fiduciary to render the services. Now these audits could be, let's say, if it is coming from the government, if the data privacy board, as an internal organization also, if it is purely from an employer perspective, if there is something which is happening, or any which was exempted, because that is part of your operations, legitimate use. So you don't need to take any additional consent from the principals in that front. However, tomorrow, if there is an audit which happens by the government entity or the board, DPDP board, at that point in time, again, you would be exempted because that's a government initiated activity. Yeah.
It was okay because that will be government related. But here it was as a organization, I also should ensure. So for that I should have an internal audit or whatever to the external audit. I should get these audited whether any vulnerability exists or not. So
Absolutely.
for that purpose,
For that purpose, that's what I'm saying. So for that purpose, you would not need to have consent from principals because first of all, that is exempted because of the employer-employee relationship. So that is for you to render services, you would be any which ways exempted. As an employer, I don't need, my legitimate use is to give employment, which means I'm exempted. Tomorrow, if I'm asking an external auditor to come and audit certain processes, at that point in time, it is only the confidentiality related clauses and the contract which has to be executed. We don't need to go back and inform or take consent from principals because we are not sharing data principals data, personal data for any other activity other than audit, and which is covered as part of my employment contract also. So you would not be required for that.
so my question was not for the employer and employee. This is as a data fiduciary. Suppose when I am designing some template, something to take the consent, because based on this DPDP Act, as a data fiduciary, they may be designing. So where they should include a clause in that code so that if your data is being used for the purpose of the safety and security and being audited, that consent should be like that.
It can be one of the points when you're designing the entire consent form if you want to, if you believe that that would be an ongoing activity. If it's a special case, once in a blue moon kind of an activity may not necessarily be required because again it's just for the audit purpose, not the entire population would be given again for that. It would be a sample based audit which may happen. So you may not necessarily want to, but if it is an ongoing continuous activity, you may want to include that in your consent form also.
Sure.
Can you present it as like here a back and we are contacting a third party auditor, say EY itself or Deloitte or any certain or something auditor is there, and we are giving access of PI data to the third party auditor who is accessing those data. We are the fiduciary and the principals are not aware. we are providing the data to them. So in this context, whether the consent will come into the picture or not.
So again, technically it should not for two reasons. One, there is no reason to give PI information in the clear form itself. If it has to be given, really it can be probably pseudonymized if we have to really give that in the complete population if we have to give, right? That's point number one. Second, whenever we also go as auditors and if we get any personal information, we do sign that entire contract which would include personal information related clauses where we have to maintain that. However, to answer your point, you don't need to go back and inform the data principals because you are still getting audited as part of your employment activities. You're not getting audited or you're not inviting an auditor for something which is absolutely outside of your employment activities or your organization what they're doing. So it is still covered from that standpoint, and at the same time, technically you should not be giving your entire HR data, entire CRM data and all for the auditors any which ways. It should be pseudonymized if you have to maintain that control.
Just to benefit of our audience, we'll take that one and come back to you. Looks like a very nuanced topic, but I think more generally explained a couple of times. So anyone would like to go ask questions?
Thank you for the session. This is Gayatri from Standard Chartered. So is the Act classifying the personal data itself into something called sensitive data with a higher degree of protection? For example, my name or my mobile number is a personal data, but in case of a disease or a specific health complication could be a sensitive data. Is it having a higher degree of protection, especially the healthcare industries?
Unlike GDPR, right?
Okay.
GDPR spoke about few categories. Here, sensitive personal data they've called out, but they've not called out what are the categories, right? So now, based on our consultation papers which have gone in, this is also one of the key criteria because they say that significant data fiduciaries, like Sujay mentioned, data localization might come into picture for significant data fiduciaries who process sensitive personal data. For them to do so, what is sensitive personal data was not clarified, but yeah, it's one of the gray area which we are also seeking consultation from media.
Okay, and one last clarification. So, except for the three categories which you mentioned, e-commerce, social media, and I think online gaming, are other data users allowed to hold or store the data indefinitely unless and until they have
Absolutely not.
agreement?
No, absolutely not.
Or is there a cap that is given by
No.
the Act for Industries?
No, but privacy principle globally says as long as the purpose is fulfilled, right? If as soon as the purpose is fulfilled, you're not obligated to hold the data there.
So the user must be able to justify the period based on the purpose, or
That's correct. So
in case
the
it comes into-
organizations must call out data schedule, retention schedule very well in place.
Right. Thank you.
Anyone would like to ask a question?
Employer-employee relationship, consent is not required. But in the many cases, actually we are taking some biometric based identity, right? Maybe iris or face, something like that. In that case also that consent is not required.
So two parts to it. One, if it is to really render employment services, you may not need to take consent. However, what happens many a times during the course of the employment, there is certain situations where you would want to collect additional information which would have not collected earlier. And it probably, as you rightly said, it could be health information to pass on additional insurance policies, for example, right? At this point in time, obviously, companies are taking further consent. That's one. Second, the very principle of data minimization, which is, let's say, you may not necessarily want to collect that information to render your employment services. You should not be, and that's where that principle of data minimization comes into force as part of this act. But to sum it up for your question, technically you are not, because that is covered until the point you can justify it as part of your employment services.
We can go for two more questions. Please do ask if anyone have. Yeah, please.
There is space, so I'll just ask a question. Say in case of businesses, like these relationship managers in a lot of businesses, right? They collect a lot of information on business account WhatsApp, for instance, right? Now, the data technically is stored with Meta, right? Who runs WhatsApp, and then we use that data with consent to process, But then what is the role of Meta in this? Because they will definitely have that data with them, and they may transform that data and use it, not transform that data and use it. We really wouldn't have sight, on that. So I just want to get your thoughts. Maybe you said it earlier and I missed it, but something that I
So
didn't understand.
again, two things. One, let's say, just to take about the example of WhatsApp, and that's where I think a year or two before they introduced something saying that all your data is encrypted within WhatsApp. That's point number one. Second, many institutions, they use WhatsApp as a channel for their business. Now all the banking institutions, etc., all your updates, etc., goes through WhatsApp many cases nowadays, right? Or even the OTPs and all. So in those cases, till the time you are not transacting personal information, it's fine. But at the same time, you would now be having agreements with a Meta or an equivalent as well, because you would be using that as one of the channels. So what happens is they become a processor for you. So you would obviously need to enforce whatever you need as part of the controls of, is the data being encrypted when it is in Meta server? Where is that? At this point in time, obviously localization is not there. So we don't know where the data even it's getting stored, whether it's in India, in US, we don't know. So all of those probably can be put across. So we know many of our clients who are using it formally. While we all use it informally, that's different, but many companies are using WhatsApp as a formal channel of business. So they have their contracts with Meta. It's a conducive business. Everybody has to play with that, and then so that's why.
So yeah, I mean there is that dependency, right?
Oh, absolutely.
By the terms of WhatsApp, and our act puts us at the mercy of WhatsApp in a way, right?
It's as simple as that. If you're using a cloud service now today, so same concept goes.
At least the cloud now, the government requires to be hosted in India.
That's not mandatory for everything. It's probably for the BFSI sector to an extent. Yeah. Yeah, absolutely. So there has to be those contracts appropriately signed and designed with Meta.
Great. So thank you very much. I think definitely it's a great session. Thank you, Sujay. Thank you, Bhavya. I think it was a lot of good information, and I could see a lot of questions coming along. And thanks for taking all the questions patiently. So with that, we just want to thank you for taking your time.
Our pleasure to be here. More than happy to address. I'm sure there will be a lot of questions probably which may not be answered right now, but happy to let us know and we'll be open to it.
Absolutely. Just token of, basically, we wanted to like present some memento. I would like call upon Ashish, please, if you can come on forward and present this to.
But go ahead, please. Go ahead.
Bhavya, come, please come. Sorry, please. I'll call upon Mr. Dinesh, GM Internal Audit, Wheels India, so to present this memento to Mr. Sujay. Please, Sujay, please come forward.